Mr. Gilo, who's your client there with you?
This is Bridget Reed, judge at 9 o'clock.
Okay, Ms. Reed, if you'll come up to the podium, please. We'll go on the record at People versus Bridget Reed, case number 236603. The record should reflect Ms. Reed is present here in the courtroom today. If I could have counsel for your appearance.
The record shown by phone people here is you on behalf of Ms. Reed.
Mr. Gilo, how did we want to proceed in this case today?
We have plea agreement. We have support to accept. She's going to plead to counts 2 and 3 and count 1.
Mr. Rolla, is that a correct statement of the plea offer?
It is, Judge, with the provision that there will be no 7411 as a sentence condition.
Okay. So again, Mr. Gilo, counts 2 and 3 with count 1 being dismissed.
That's correct.
Ms. Reed, have you had a chance to talk to Mr. Gilo about this plea agreement?
Yes, I am.
And is that how you want to proceed today?
Yes,
Can you raise your right hand, please? Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you. Ms. Reed, are you currently on any kind of probation or parole?
No,
All right, and you understand that the maximum penalty you could face for possession of cocaine is up to 4 years and or a $25,000 fine?
yes,
And the maximum penalty you could face for operating a motor vehicle without insurance, that's a misdemeanor of up to 1 year and a maximum of a $500 fine. You understand that?
yes,
With those things in mind, what is your plea to those 2 charges today?
I'm guilty.
Right now, you have certain rights. I'm going to go through those with you. You have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you appear at trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf appear at trial. You have the right to remain silent during a trial and to not have that silence used against you, and the right to testify at a trial yourself if you want it. Do you understand all those rights?
Yes, I do.
And you understand that you're giving up and waiving all of those rights by pleading guilty.
Yes,
Also, you don't have an automatic right to appeal the plea that you're making here today. If you wanted to try to do that, you would have to ask for the Court of Appeals to hear your case. They could say no, and that would be the end of any appeal. You understand that?
yes, I do.
Has anyone threatened you with anything to get you to plead guilty?
No,
Has anyone promised you anything other than what we've said here in court today?
no,
Is it your own free choice to plead guilty?
yes,
Are you pleading guilty because you are guilty?
yes,
Right. This happened back in August of this year, is that correct?
yeah,
Okay. On or about August 1st of 2023, were you here in Otsego County?
yes,
Okay, and were you driving a Lexus on I-75 here in Otsego County?
yes,
At the time you were driving that, did you have proper insurance on that vehicle?
no, I did not.
Okay, and was that part of a traffic stop? Were you pulled over by the police?
Yes,
Okay. At that time, did you also have some cocaine in your possession?
yes, I did.
Did you know that that's what that was?
Yes,
Did you have any legal right to have that at that time?
no,
Great, thank you. Mr. Roller, are the people satisfied with the factual basis?
Yes, Your Honor.
Mr. Kilo?
I'm satisfied with the factual basis.
Mr. Rolla, are the people aware of any threats, promises, or inducements other than what's been placed on the record?
None by the people. We're also satisfied the person by the courtroom statute as to acceptance of guilty pleas.
Thank you, Mr. Kilo.
I agree that you complied with the statute and that there's been no other promises that's to have my client enter a guilty plea.
Thank you. Ms. Reed, the court finds that your plea is knowing, voluntary, and accurate. The court is satisfied there is a factual basis to support a finding that you are guilty of each of these charges. The court will accept your guilty plea as the whole. We'll set this matter for a sentencing hearing. You're going to meet with Ms. Davis here before you leave the courtroom for a pre-sentence report, okay?
okay,
All right. Just make sure that you stay in touch with Mr. Gilo prior to that next hearing for sentencing, okay?
okay.
Thank you. That's all for today.
Thank you, Judge.
Who's Miss Davis?
She's with me.
Oh,
Mr. Thompson, who have you got there?
Yes, I'm here with Mr. Edwards.
Oh, People versus Landon Edwards, case number 226434. The record should reflect Mr. Edwards is present here in the courtroom today. If I could have counsel of your appearances on.
Thank you. Record call back.
Thank you. I'm Jason Thompson, appearing on behalf of London Edwards. I believe the court received our substitution for Mr. Kilo, who's the former attorney in this case, but I've taken over. We're prepared for trial. I understand it's scheduled for November 29th, but I understand from my partner that might not be able to occur because there may be a lodge case on that day.
I did have my list of pending trial dates.
I know my partner, Mr. Truth, represents Mr. Killing.
Okay.
He's scheduled for November 29th. My understanding is he's lodged, so that's my understanding of our status.
Yeah, I think
I would concur that the Killen trial has priority. It is scheduled for trial. And in fact, I even met with Mr. Truish yesterday. We may have eliminated 2 of the 17 witnesses.
Okay, but either way, it sounds like we would not be able to proceed with Mr.
No, Your
Edwards.
Honor.
Okay, so the court will reset this for another trial date. We have it set for a 1-day jury trial. Mr. Rolla, do you still think that's an appropriate amount?
I
of
do,
time?
Judge.
Mr. Thompson.
That sounds appropriate, yes.
Okay. Mr. Thompson, are there any, I know you've just been added to the case a little over a month ago. There are continuing discussions. Do we need to set this for a final status conference or should we just set it for the trial?
I think we can set it for a trial date. I might have a motion in May. So I'll try to get that filed, but yes, I think it should be set for a trial date.
Okay. So we'll set it for a 1-day jury trial at the court's next available date. The court will set it for a final status conference. To the extent either side has any motions, they should be filed and set for hearing no later than the date of that final status conference. Mr. Rolla, anything else I can address for the people today?
Not in this matter, thank you.
Mr. Thompson,
Nothing else. Thank you.
Mr. Edwards, do you have any questions at all?
No, sir.
Okay, thank you. That's all for today. Thank you.
Is this Mr. Rowe?
It is, Judge.
Okay.
Run the record in People versus Rowe, case number 23653-1.
The record should reflect that Mr. Rowe is present here in the courtroom today. If I could have counsel put your appearances on.
Record, John, my call back. Gary Kilo on behalf of.
So there was an order for evaluation for criminal responsibility. The court received on October 17th notice from the state center that Mr. Rowe did not appear for his appointment for evaluation. I mean, in my view, that's with regard to criminal responsibility. It's not a competency issue, so I think we can still continue to go forward. But Mr. Kilo, can you tell me where things are at in this case?
Well, we still want forensic on it. I know that when I talked to him, he I told him to get a hold of community mental health, set up the forensic exam. And I don't know if he did that.
I've talked to community mental health and they're willing to cooperate or facilitate the appointment.
Is there a reason why you didn't?
Honestly, Judge, it was just stupidity. I wrote down the date and I got it mixed up. It was just a phone call. They never sent me anything on that. It really was just an honest mistake, Your Honor.
All right, Mr. Rowland.
Judge, Mr. Rowe didn't appear. We were in fact going to be asking for a bench warrant, but he's here now. As far as why he didn't appear, I can't speak to that. I don't know. All I know is he did not appear. it's headed for one more attempt at evaluation, but in people's position, if it doesn't show up for that one, I think it's a situation where you should waive that right, because this is just delaying matters unnecessarily.
All right, so I agree with Mr. Rolla. Mr. Rowe, this is a defense that you're kind of investigating. The court's giving you an opportunity to do that. And have you evaluated for criminal responsibility? I mean, either it's important to you or it's not, and you're either going to show up for your appointments or you're not, but I'm not going to schedule it again after this. I agree with Mr. Rolla. The court's just going to consider Mr. Delo any kind of temporary insanity defense or any other defense related to criminal responsibility to be waived, fails to appear for the next one. So, Mr. Delo, the court will just ask that you prepare a second order for that evaluation. Once that's submitted, the court will sign it. And then we'll set this for another status conference. I think I would like to get this on the trial calendar, and we can work in time for this to occur for that. But I think this was bound over back in May, and we're really closer to resolution here in November than we were then. So, Mr. Rolla, the time frame aside, in terms of when the court sets it for trial, in terms of how many days of trial do you think, how much do we need in this case?
Judge, in this particular matter, we've only got 6 witnesses, and I've gone through what their testimony is anticipated to be. It's probably a day and a half at most. Many of the witnesses are basically confirming what the other ones have said.
Okay.
Although there is a video too as well.
Mr. Delo, do you think that would be enough time?
Yes.
I'm going to set it for a 2-day trial just to be safe. And the court's going to set the trial date out at least 4 months. I think that should be more than enough time to get the evaluation done, have the parties have an opportunity to review that, and then further discuss any plea arrangements. The court will set it for a final status conference. We have a plea. At that point, we can take that. If not, then we'll have a trial date ready to go. Mr. Rolla, any other matters I can address for your side?
Thank you. Thank you.
Mr. Delo?
Nothing further, Jim. Thank you.
Okay. Mr. Rowe, do you have any questions?
No, Your Honor.
Okay, thank you. That's all for today. Just make sure that you stay in touch with Mr. Delo.
For the record, Judge, he has,
Okay, thank you.
since my involvement.
Great. Mr. Wilson, are you able to hear me okay?
Yes, sir.
We're on the record in People versus Troy Wilson. This is case number 195726 and 236578. Mr. Wilson present today by video from Department of Corrections. One question I have, and I guess I might need counsel to help remind me where we're at with it. I know we have a sentencing set for the newer file, the 236578. Are we doing sentencing on a probation violation too today?
Judge, I advised the court that our office was contacted by the Attorney General's office this morning. And in fact, I'm understanding that they have a representative here in person. The other file.
Okay, So this is set for 9:30. We're about 10 minutes ahead of
Correct,
schedule.
Judge, that's why I wanted to bring it to the court's attention.
Okay, so, Mr. Wilson, we've got some other people involved in the case, that aren't here yet, and your hearing's set for 9:30, so I'm gonna put you on hold for about 10 more minutes, okay?
Judge, while
Yes,
he's
Your
still
Honor.
here, I do have some additional information this, Davis reminded me of. The court didn't request a separate PV report because it's contained in the PSIR.
Okay, I just wanted to make sure because of the different files, and
Very
then
good.
Mr. Wilson and other files tomorrow. It's a lot of moving parts here and I got 3 different attorneys, so, okay. Okay, Mr. Wilson, we'll be back on the record in about 10 minutes.
Yes, sir.
All right, looks like we got everybody connected. We'll go on the record in People versus Troy Wilson. Again, we have two cases, 195726 and 236578. Both these files are set for sentencing today. With regard to the pre-sentence report, Mr. Wilson, have you had a chance to go through that pre-sentence report and speak with
Yes,
your
Your Honor.
attorney? Okay. All right. And dealing first, as indicated when we took our break, both reports are kind of combined into one. Mr. Gilo, as it pertains to your file with Mr. Wilson, are there any additions, deletions, or corrections?
No, Your Honor, we're satisfied. The scoring is over.
Okay. And Mr. Brown, as to your file, which I believe is the probation violation file, any corrections need to be made to the report?
No, Your Honor.
And then Mr. Gilo, any challenges to the scoring as to file 236578?
No challenges. Thank you.
Okay. Just so defense counsel and Mr. Wilson are aware, I did receive a number of letters on behalf of Mr. Wilson in relation to both files. And I did have a chance to review all those letters prior to the hearing date today. As to file 236578, Mr. Rolla, do you have any additions, deletions, or corrections or challenges to the scoring?
No additions, deletions, or corrections as to the body of the report, nor challenges as to score votes. Thank you.
Thank you. And Mr. Ayani, you're here on behalf of the Attorney General's office with regard to the probation violation file.
That is correct, Your Honor. Good morning.
Good morning. Did you have any corrections that you wanted to have made to that report?
No, Your Honor.
Okay. Mr. Rolla, as to file 236578, which is the possession of methamphetamine, any allocation?
Yes, Judge, as indicated in the PSR, this is a gentleman who obviously has substance abuse issues. He absconded on his Crawford County Circuit Court matters. These are his 6th felonies, his 8th controlled substance convictions. It's a situation where many of his prior felonies involve methamphetamine. He has 12 scorable misdemeanors, countless non-scorable misdemeanors. And in addition to that, obviously the court's well aware of his other matters. I'll let the AG's office handle those. But this is a defendant, quite frankly, who does not deserve SAI. He needs an extensive prison sentence for 2 things. One, to hopefully have him finally quit his meth habit, which apparently has been controlling his life for quite some time. And the second, quite frankly, to protect society for persons like him. There's a recommendation of 18 months to 10 years, and I think it's a 3 days credit, if I recall correctly. I think that's probably an appropriate sentence, so I'd ask the court to oppose the same.
Thank you. Mr. Ayani, did you have any victims that wish to address the court today on the probation violation file?
Unless there's somebody in the courtroom that I can't see, I'm not aware of any, Your Honor.
I see Ms. Dazinski, who I believe is the recipient. She's present by Zoom. She has not turned on her camera or microphone. Did you want me to inquire of her?
Yeah, would you? Yes, please, Your Honor, if she's interested in making a statement.
Sure. Ms. Dazinski, can you hear me?
I can, Your Honor.
Was there any statement that you wanted to make as a victim in the child support file?
Just furthermore, the Attorney General, the simple fact that it's clear that he has and continues to have a methamphetamine problem on top of not providing and supporting for his children. It's been 9 years since he's had any contact with his oldest daughter. He may say that I don't allow it, or that he doesn't have my phone number or whatever the excuse may be, but he has plenty of ways to contact outside parties in regards to wanting to sign off on Brooklyn, his oldest daughter, which if he can find a means and a way to reach out for that, he could find a means and a way to reach out to make simple contact, or a birthday, a holiday, $20 even would be more than what he's even attempted to do in the case of his child. Not only does he have a methamphetamine problem, he also has a domestic violence issue on top of it. The 18 months to 10 years, is that just for the methamphetamine, or is that all counts and situations considered?
That's for the methamphetamine on the probation violation. The time he has left on that is 6 months.
Okay, that's not for the issue at hand. That's just for what he's sitting for now, correct?
The 6 months would be the time he has left to serve on your child support case.
So
the 18-month recommendation goes to the methamphetamine charge.
okay, so 6 months to sit for 9 years of not supporting his child. I mean, personally, I don't think that's good. Like, I think that's like a slap on the wrist, like he's gotten over and over again. Failure to appear, failure to pay, fleeting and eluding. I mean, obviously you'll take that into consideration, but that's just my opinion, my point on it. And thank you.
Okay, thank you, Ms. Dazinski. I appreciate your statements here today. Mr. Ayani, anything you wanted to say with regard to sentencing on the child support file?
No, Your Honor, we understand the court's limitation on the cases, but we do view this as basically rolled into one case since this sentences will be served concurrently. We would ask that probation be revoked, that he be sentenced to prison concurrent with the other case. He's used up more than as many second chances as the court has provided, and I believe it's something more needs to be done to gain his attention.
All right,
We would
thank
support
you.
the prosecutor's recommendation.
All right, thank you. Mr. Gilo, as to the methamphetamine charge, anything on behalf of Mr. Wilson?
Well, it would appear that Mr. Wilson is going to be in jail with respect to his other charges there. We'd ask that these charges run concurrent, and we'd ask the court to consider boot camp. The rule would appear that what we need here is my client, Mr. Wilson, to get fully employed, start paying off and paying his mother of his children the child support. And if the court allows the boot camp in prison with respect to the recommendation, he would be able to accomplish that.
Thank you, Mr. Brown. Anything on behalf of Mr. Wilson on the child support file?
Your Honor, I don't have a lot to add to what Mr. Gilo just said. If he does have an opportunity to get out on boot camp, he can continue to work. He clearly needs some help. He does have support outside, which I think the court can see from the letters that were received. There is some potential here. He just needs to get the help that he needs, and hopefully he will do that.
Thank you. Mr. Wilson, was there anything you wanted to say today?
I asked the court for leniency. I asked that boot camp be an option as it's disciplined and structured, and that's something that I do need in my life. I do own a business, so I accept my responsibilities. And that this does look bad as a business owner. I have made arrangements in prison to get on substance abuse programs, and I plan to keep that going on after prison to transfer into sober living. I've moved my business and myself out of the county that I currently was located in to try the saying people, places, and things. Change that first. As I like to say, I'd like to say I'm sorry to the courts. I'm sorry to Special Attorney, Assistant Attorney General Larry Brown, my lawyer Gilo, and also to the courts. Danielle as well.
All right, thank you. I've had a chance to review the pre-sentence report in this case. Mr. Wilson, I mean, I'm well familiar with you. You've been in front of me on a number of cases, both here and in Crawford County. Those cases have involved criminal charges, drug charges like the one we have in the newer file here today. Friend of the court cases with your 4 different children, and I know there's several different mothers involved. Personal protection order cases, a lot of different types of proceedings over the past number of years. So I'm well familiar with you and your circumstances and your past history. I did have a chance to review those letters. The letters are very complimentary of you as a person. I don't know how well those individuals, know or understand what your background or history is. But that's something the court takes into account. I certainly take into account what Ms. Dzinski's had to say here today. I suspect it probably wouldn't be much different than the mothers of your other children in terms of the child support issue. I'm sure that you have been battling an addiction problem. The nature of the charges, as well as the circumstances that bring you before the court in this and the other cases, make that very clear. I don't know what efforts you've made, if any, to deal with that, but until you do, you're going to end up in the same place over and over and over again. I think you've used up every possibility of any kind of community sanction. There's been numerous chances on probation, numerous jail sanctions. Frankly, I'm surprised that this is the first prison recommendation that you've received, given your past history. And I think you've had it 9 times on probation, 9 different jail sentences with no prison sentences. So when we get to that point, it's clear that the previous efforts by the court through probation, through jail sentences to correct behavior haven't been successful. And so now it's time for a different type of sanction. In terms of the sentence on the methamphetamine charge, I think a sentence at the top end of the guidelines is warranted given the circumstances in this case and your past history. I also agree that the maximum sentence on the probation violation file is appropriate. And Ms. Dzinski, I certainly understand your frustration with the system and the level of sentence. As a practical matter, given the charges on the drug issues, Mr. Wilson is facing much more time on that, and any time that he would serve on the child support issues is going to be subsumed or basically taken up by his prison sentences on the drug charges.
Your Honor, can I add something to this, please?
Sure.
Just on Mr. Troy Wilson's behalf, he has always actually been a very hard worker. He has the potential to be something. I don't mean to sit here and speak negative about him as a person. Him as a father is obviously doesn't have my highest opinion of him, but him as a person, he does have the ability to be a hard worker, to be a good person, to be, a good function in society. It's not that I want to see him get the worst or the books thrown at him. I just want him to be the best that he can be, not just for his children, but for himself. I don't know if he would ever be able to rekindle the relationship of him and Brooklyn, but even for the sake of his other children, I just wish that he would get a grasp on society and reality and realize that there's more out there than, violence, drugs, alcohol, and just the life that he's living in general. I think that he does need rehabilitation and structure. And I guess that's all else I have to say.
All right, thank you. I appreciate your statements, and I think it's a very generous point of view for you to take, and I hope Mr. Wilson takes those statements that you made to heart as well.
Thank you.
And I think you point out a good fact too, which Ms. Dzinski, which is that I'm going on Mr. Wilson's criminal behavior here. Not making judgments as to his character or anything else. That's really not my job. My job is to address the goals of sentencing based on the wrongful behavior that he's engaged in. So there's certainly room for those things that you mentioned, Ms. Dzinski, but as it relates to his criminal behavior, he's really at the end of the line in terms of rehabilitation. I mean, there's been 9 times on probation with attempts to address rehabilitation. And at some point, as much as people in Mr. Wilson's personal life may want to have him seek rehabilitation, at some point the court isn't going to put any more community resources towards that when it's been unsuccessful so many times.
That's understandable. I guess, and that was if he could get some sort of rehab while he's in prison, to be able to learn to function without the addiction and the dependence of drugs and alcohol for a normal, sober living life outside.
Understood. Thank you. So as it relates to the methamphetamine charge, the court finds that an appropriate sentence is 28 months to 10 years. Mr. Wilson on that file does have credit for 3 days served. The court will order a crime victim's assessment in the amount of $130, court costs of $325, attorney fees of $350, the DNA testing fee of $60, and a $68 state cost. On that file, the court does not find that the boot camp program is appropriate. I agree with the prosecutor. I think Mr. Wilson needs to spend some time in a different facility, in a different environment, rather than being released early for work camp purposes. And again, I think there's been enough community resources directed over a period of time towards rehabilitation that at this point, the court is looking more towards punishment. In terms of the probation violation file, the court will discharge Mr. Wilson unsuccessfully from his probation. The court will impose 6 months in the Otsego County Jail, that time to be served concurrently with his time in the Department of Corrections. The court will reserve any outstanding fines and costs on that file. Mr. Wilson, you do have the ability to appeal both of these sentences. If you haven't already received it, the court will provide you with an acknowledgement of your appellate rights. That will explain to you how to seek an appeal as well as how to request a court-appointed lawyer to help you with any appeal in this case. Mr. Rolla, is there anything further we need to address?
None from the people's side, Judge.
Mr. Ianni, anything further from your side on behalf of the AG's office?
No, Your Honor. Thank you very much.
Mr. Elo or Mr. Brown?
Nothing further. Thank you, Judge.
Nothing further, thank you.
All right, that concludes this hearing. Mr. Wilson, you are remanded to the custody of state at this time, and all parties on this case are free to disconnect.
Thank you.
Mr. Stimmer, are you able to hear me okay?
Yes, Your Honor.
Okay. Run the record in People versus Stimmer. This is case number 216176, 226316, 226317. Record should reflect Mr. Stimmer is present today by video from Department of Corrections. And I can have counsel put your
For the record, Your Honor, my call is out for the people. Gary Gill on behalf of Mr.
This is the date and time set for sentencing. Mr. Stimmer, have you had a chance to go through the pre-sentence report and talk to Mr. Gill about that?
Yes, I have, Your Honor.
Mr. Gill, are there any additions, deletions, or corrections to that report?
None, Your Honor, thank you.
Are there any challenges to the scoring of the guidelines?
No, Your Honor.
Mr. Rolla, do the people have any additions, deletions, or corrections?
No, Judge, no challenges to the scoring. Thank you.
Thank you. Do the people have any victims that wish to address the court?
We do not, Judge.
The record should reflect I did not receive a separate impact victim statement written, but I did review the statement made by Mr. Moore in the PSI. Anything for elocution, Mr. Rolla?
Yes, Judge, thank you. Court's well aware of Mr. Stimmer, his history, his background, it's reflected in the PSIR. These are his 6th, 7th, and 8th felony offenses, all theft related. He's got 17 prior misdemeanor scorable offenses. He's affected another lifelong criminal, and quite frankly, as accurately described in the PSIR, a quote, menace to our society, end of quote. As long as he's out of incarceration, he's a threat. He's gonna rob, he's gonna steal, he's gonna do things that harm other people. The recommendations in this particular case, I think, are appropriate, along with the restitution of $921 to Mr. Moore in file number 226316, with the recommendation of 28 months to 15 years. In file 226317, 28 to 7.5, and in file 226317, 28 to 15, with 53 penalty days credit. I think that's appropriate, and I think that's the only thing the court can do to prevent Mr. Stimmer from continuing to commit felonies at the costs of the persons in our society.
Thank you. Mr. Elo, anything on behalf of Mr. Stimmer?
Yes, Judge. As it relates to the unlawful driving away in automobile, I'd like the court to know or take into consideration that is the same vehicle that Mr. Stimmer was driving in Roscommon County. He got pulled over. He got charged with unlawful driving away in automobile, and he did 12 months in the Roscommon County Jail. So I'd ask the court to take that into consideration. Mr. Stimmer, yes, has a history, but in light of the fact that he has been incarcerated, he is for some time now on other files, I'd ask the court to consider the middle of the guidelines for a sentence in this particular matter.
Thank you. Mr. Stimmer, was there anything you wanted to state for the record today?
Yes, Your Honor, I just wanted to say that I'm very sorry for what I've done, and this time in being incarcerated has taken a I'm taking it very seriously. And my brother just died since I've been in here of MS. I didn't get to see him before he died or get to go to the funeral. My dad is dying and needs me out there. I also have 4 kids, and I'm trying to straighten my life out so I can be out there for them. I have a lot of good things going for me. When I do get out, I still have a job with Zarimba Equipment. I'm also signed up for auto mechanics to get some more certificates while I'm in here. I currently just now passed through, I got a certificate through ASAT while I've been in here, Advanced Substance Abuse Program. I'm doing the best I can in here to stay focused on getting out and have a positive plan for when I do get out, and to never mess up again. I'm really sorry for what I've done. I just want to be good when I get out and not get in no more trouble.
All right, thank you. I have had a chance to review the pre-sentence report, so I'm familiar with the facts of the files that bring you before the court here today. I also had a chance to review your background and history. And Mr. Stimmer, you've been in front of me for a number of different cases in the past before going back probably 10 years. And it's clear, your history, as you well know, is not good. You have quite a few convictions on your record. You've had 6 prior jail sentences, 8 prior times on probation, a couple different prison sentences as well. So certainly your conduct in this case doesn't reflect that any of those prior instances has corrected your behavior. There were victims involved in this case, or at least one victim in particular, Mr. Moore. Looking at all the circumstances, and I think, I really think Mr. Gilo did a good job of negotiating an agreement in this case that, in spite of your record, calls for, a fairly short, in my view, given your past history, prison sentence, even at the top end of the guidelines. And the court would note that because you're on bond, that the court has the ability to impose consecutive sanction, which would greatly lengthen the amount of time that you would spend in prison. I'm not going to do that because I think there are some mitigating factors here that you've pointed out, Mr. Stimmer, and in the hopes that you're going to make some changes going forward. But as it is, the court finds that sentence within the guidelines, but at the top end, is appropriate to account both for your conduct in these particular circumstances, as well as your past history. So as to file 226316, the court will sentence you to a period of 28 months to 15 years in the Michigan Department of Corrections. On that file, you do have credit for 53 days served. The court will impose restitution in the amount of $921 that's payable to the Otsego County Clerk to be dispersed to Walter Moore. The crime victim's assessment of $130, court costs of $325, and attorney fees of $350, and a state cost of $68. And that's as to count 1, breaking and entering intent. As to count 2 in that file, a $68 state cost. As to file 226317, I'm sorry, as I want to go back to 226316, as to count 2, 28 months to 7.5 years and a $68 state cost, those to be served concurrent to each other. As to file number 226317, 28 months to 15 years, crime victim's assessment of $130 and a state cost of $68. That sentence to be served concurrent to the sentences in file number 6316. You do, and on that file, 53 days of credit. You do have the right to appeal all of these sentences. If you haven't already received it, you will be provided with some paperwork that explain to you what your appellate rights are, as well as how to request a court-appointed lawyer to help you with any appeal. Mr. Rolla, anything else on behalf of the people today?
No, please, Your Honor, thank you.
Mr. Stimmer, you are remanded to the custody of the state at this time, and all parties are free to disconnect. Mr. Gilo, were you ready on Ms. Clark's case, or do you need a second to speak with her?
Yes, yeah.
All right, we're on the record in People versus Sierra Clark. This is case number 216098 and 226458. Record should, record should reflect Ms. Clark is present here in the courtroom today. If I could have counsel for your appearances on.
Thank you, Judge, for the record, on behalf of people, here to you on behalf of Ms. Clark.
All right, this is the date and time set for sentencing in these files. The court previously adjourned sentencing because we had some challenges to guideline scoring. A couple things I want to address before we get into that. So, Mr. Roll, I just want to make sure that I understand your challenges, because I think there were some typos in your.
I think there was, Judge, and again, go ahead.
All right, so as the file 6098, challenges are to OB 14 and 15, and then as to file 226458, challenges are to OB1 and OB19. Is that correct?
I think that's correct, Judge. That's why
No, I'm sorry.
Wait.
6458, OB1 and OB19.
Correct, as indicated in paragraph 9, I believe.
And Mr. Gilo, I did receive your memorandum as well. I had a chance to review the submissions of all the parties in this case. So Mr. Rolla, as to, we want to start with file number 216098, and that's the file, the charges from April of 2021 involving the Meyer parking lot incident.
So methamphetamine situation.
And so anything that you wanted to state for the record in support of your argument on OB 14.
Yeah, Judge, I don't want to be repetitive, but as to the issue of who's a leader, this is specifically dealing with OB 14, as the court's well aware, pursuant to MCL 777.44.2b, you can have more than one leader, but there are 3 or more people. In the facts in this particular case, we had two particular defendants, one of whom, the driver and that was, of course, Baumgartner, and she could be dealt with tomorrow. You could say she was a leader because of the stuff that was found in the vehicle. I think also in this particular case, however, because you have Ms. Clark, who was also found with additional methamphetamine, including, if memory serves me correctly, hidden literally in the lining of her jacket, which wasn't even located until after she went to the Kalkaska County Jail.
So here's where I think we're conflating two different incidents, because the jacket incident is from file number 6458 from October.
And I understand that, Judge. While I know that's the other incident, my point is the court can take for sentencing all the circumstances that are coming in, all of her criminal behaviors. And I'll address that in the other cases to do it that way. That's fine. That's just one of the indications of what she was doing. You have three parties. There was obviously a lot of drugs. It's a situation where, because of the amount of cash that was found, the baggies, the digital scales, we believe, the people believe in any case, that this was a group of individuals that together were in fact arranging to sell controlled substances. We think that there could be more than one leader in this particular case, which is why, and it's kind of odd in this matter, that's why I said there could be a number of different scoring variables depending on whether or not this court's going to score 10 points for the defendant under OB 14. And then, of course, you have the additional situation of her involvement, but that if the court wants to address it, that can, of course, address to the other file. Again, it can go either way. I just don't think it's appropriate to look at this in a vacuum to say, well, now we can ignore that those other things happen, because I think, quite frankly, when we're dealing with drug cases as we are in this matter, I think all of them should be considered. In any case, Judge, if the court were to add either points under OV 14, or of course, then we have the 5 points under OV 15, it's not going to change her scoring range because the level still stays at 1 without the 10 points. With the 10 points, it changes. Without the 10 points, it doesn't change. And if you want, I'll address the other file then separately after this sentencing in this file.
Yeah, I want to take the two.
And again, that's fine. I don't have any problem with that regard.
Okay. All right, Mr. Gilo, as to OB 14 and 15 on the Meyer parking lot.
Judge, I believe that we sent you a documentation of what our position is relative to that. And I'd ask the court, I'm not going to repeat it. I know the court's read it. That's our position. That she's not a leader, that she is qualified for so-called drug court. And I'd ask the court to rule that one.
All right, so I did review OB 14 and OB 15. In order to score variables, the court has to find that there are facts to support the scoring by a preponderance of the evidence, and the court can view information contained in police reports, prior sworn statements at other hearings, information contained within pre-sentence report. In this case, OB 14 involves Ms. Clark's role and allows for scoring of 10 points where Ms. Clark was a leader in a multiple offender situation. We certainly have a multiple offender situation here. And I don't think the court has enough evidence to show that Ms. Clark, as opposed to anyone else, was an actual leader among these three individuals. In my view, it sounds to me from what I read that we got three individuals heavily involved in the use of substances, all using at the same time together in the parking lot at Myers. And I don't think there's enough evidence to get the court past a preponderance level of finding that Ms. Clark was a leader, or really that any of the other ones were leaders either. I think we've got three essentially equal people all using together. So the court doesn't find that there's sufficient facts to support scoring under OB 14. In spite of that, and in spite of the court's, I think, evidentiary inability to conclude that any of one of them is a leader, I think
based on the circumstances, the amount of substances that were found, the types of paraphernalia that were present as well. That there's enough evidence to show that there was indications of trafficking or dealing, the amount of drugs, whether that was just among the three of them or with other people. I think there's sufficient evidence under preponderance standard to show that there are indications of trafficking here. So the court is going to have OB 14 remain scored at 0. The court is going to grant the prosecutor's objection as to OB 15 and score that at 5. So that takes the OB level or total OB points to 5, but doesn't change the level or the guidelines, which would remain at 10 to 23 on that file, and that's 6098. And then with regard to 6458, which is the incident where the throwing star was found and the drugs were found in the jacket at the jail, the challenges are to OB1 and OB19. Mr. Rolla, as to those two, any further argument that you wanted to present?
Judge, contrary to defendant's response, this has nothing to do with whether or not the weapon involved is Chinese or described as Chinese. It was described in the information as quoted 4-sided double-bladed throwing star. That's what it is. That's what it was. And the fact that it's a pointed double-bladed object, which means it's a stabbing object. It's a weapon, obviously, as indicated under OB1. And points should have been scored as a weapon, not 0 points. I don't know how much more I can argue that point, if you'll pardon me. In that regard, as to the controlled substances subsequently found in the defendant's jacket in the Calcasta jail. Again, that goes effectively not then to OB1, that would go to the situation of effectively OB19 for perhaps interfering with the investigation, trying to hide drugs, etc. And again, it wasn't scored in this particular matter. The court could effectively, in the people's position, as indicated under paragraph 7, pursuant to MCL 77749C, score 25 points because effectively, as the case law has indicated and has correctly recognized, although maybe bringing a cell phone into a correctional institution doesn't specifically endanger the correctional institution, bringing drugs in fact, has, and I pointed that out in my response. If the court did not want to score it at 25 points, it could also be scored at 10 points from the mere fact that she tried to hide the drugs by having them in the lining of her jacket. Now, she can always make the argument, well, I didn't know they were there, except, quite frankly, I think by far more than a preponderance of the evidence, in light of the fact that, as I indicated, I would refer back to the prior Meyer incident, this is really clear that she uses controlled substances, the same type of controlled substances that were not concomitantly being used by the 3 individuals, but also in fact then subsequently found in her jacket. She was trying to smuggle them into the jail. The people submit either for her own use or worse yet, to dispense inside the jail. In either case, as both our Court of Appeals and our Supreme Court's found, that specifically can cause a danger to the correctional institution. So either 10 points or 25 points would be appropriately scored under OB19, not 0 points.
Thank you, Mr. Hilo. Any additional argument?
No, I don't.
Can I say something?
Other than we disagree with Mr. Roll's recitation.
Ms. Clark, I'm going to rule in your favor on this, so
Okay.
don't snatch defeat out of the jaws of victory. The court had a chance to review the report in this case. Looking at OB1 first, in the court's view of OB1, it has to be more than just possession of a weapon to score OB1 under 5 points. The weapon was displayed or implied. In this case, looking at the police report, the star was found inside the glove box, I think after Ms. Clark was taken into custody. So certainly, I think that supports a possession, finding a possession, but I don't think there's nothing in the PSI, which is the only information the court has to go on, indicate that that weapon was displayed or there was some kind of implication that she had a weapon by any of her actions here. So the court finds that there isn't any evidentiary support for scoring
5 points for OB1. With regard to OB19, I absolutely agree with the prosecutor's statements, and I think it's a correct statement of the law that bringing drugs into a jail can constitute scoring under OB19 at either a 10-point or a 25-point level. I've had hearings on this before. I think case law, though, draws a line between potentially bringing those narcotics into the jail for purposes of using them in the jail or distributing them in the jail, which I think would support a scoring as opposed to simply having those substances in somebody's possession when they're at the jail, being brought into the jail. And I don't think merely being in possession is enough to score under OB19. I think the court would have to find there was some kind of intent to interfere with the administration of justice or the safety of the jail in the way and other circumstances involved in the bringing of those drugs, such as the way they were brought in, so forth. Efforts may be concealed. There would have to be other facts. What the court has to go on here in the PSI, which again is the only information the court has on this, is Clark was arrested on her warrant, was transported to Kalkaska County Jail for processing, and was in possession of a clear plastic bag with crystal-like substance in the inside liner of her jacket. And I think given other facts that could support a scoring, but based on that information, which is again the only information the court has to go on, I don't think that provides the kind of circumstances which would allow the court to find that she was bringing that substance in for the purpose of interfering with the administration of justice or affecting the security of the jail. Just based on that, she had it, and then that's just not enough, I think, as a case law. So court finds that there are facts sufficient to support either scoring of OB1 or OB19. The court will deny both those challenges. So as to file 6458, the guidelines remain 2 to 17 and 9 to 23. Mr. Gilo, are there any other corrections that need to be made to the PSI other than what we've already addressed?
Oh, yeah,
And do you have any challenges to the scoring?
I do not.
Right, Mr. Rolla, do the people have any corrections, additions, or deletions?
No, Your Honor, thank you.
Okay. One other thing, and Mr. Hamlin has connected in, there was a statement in Mr. Rolla's supplemental brief indicating that Ms. Clark is no longer eligible or not participating in the drug court.
It's my understanding, and again, I got that right from Mr. Fenton of our office, who's on the drug court board, that Judge Cooper found her not to be appropriate for drug.
Mr. Gilo, do you have any objection to me having Mr. Hamlin comment on the current status?
No, Judge, no, indicate to the court she was,
I reported this morning.
she reported this morning.
Well, we're gonna have Mr. Hamlin tell us what the situation is here. I think he's probably the one in the best position to do that. So Mr. Hamlin, I know I brought you in a little bit late. We were dealing with some scoring guidelines challenges, which didn't necessarily have anything to do with drug court, but we have Ms. Clark here. Can you tell me her current status and whether or not she would be eligible for the drug court?
Good morning, Your Honor. Thank you. Her current status, just 1 second, sir. Currently to date, she has 57 days in this program. Again, she is on the bond conditions through your court, allowing her to participate in the program. She's been sentenced in Kalkaska County to the drug court program here in Otsego County. I think it's relevant for the court to be aware that there has been a couple of drug screens that are questionable, and right now those screens have been sent out to Redwood Toxicology in California for review and any confirmation. She again is doing relatively well in the program. It's just a matter of getting the drug screens to indicate negative.
All right, Mr. Rolla's indicating that there's been some findings or rulings by the drug court committee that she would not be eligible, or that the court, she wouldn't be accepted if the court sentenced her into that. Can you speak to that?
Only on the bond conditions that were signed by the court judge. You know, if something was challenged and it wasn't deemed appropriate for her to be in the program, then those bond conditions, of course, would be revoked and she wouldn't be in the program anymore.
Your Honor, if there might be some assistance.
Well, hold on one thing. So Mr. Hamlin, I mean, has she been screened? Would she be accepted if I sentenced her into that today?
She would be.
Okay, all right. Thank you, Mr. Roll.
Yes, Judge, I guess the inquiry is, and the information I was specifically given by APA Fenton, is that with the findings of the judge, that Judge Cooper actually this defendant did.
And that could be as a sanction, but I don't know that
And
that
again,
means
it
that
was
she's
the information that was passed on to me is because of that, then she wasn't going to be eligible for that drug court. Now, if what I hear now is that she would be, I don't know what's going to be the result if those screens come back not negative, but in fact come back positive. I guess that would be the inquiry as to whether or not the drug court is going to allow her to continue.
All right, Mr. Roll, anything else that you wanted to say for allocution in this case?
Judge, I understand the court's ruling on the weapon. Again, it is what it is. It was found in the vehicle. Obviously, she pled guilty to the charge. That's why she's here being sentenced on that particular offense. I leave for sentencing that further to the court.
Thank you, Mr. Kilo.
Judge, I really have nothing further to add. Court has a pretty good eye on what's going on in this case.
Ms. Clark, is there anything you wanted to say? All right. So I've had a chance to review the files. I've had a chance to go through the PSI, obviously. Pretty in depth, so I feel like I'm pretty well versed in facts here as well as your past history, your circumstances. There's no question in my mind that you do have a serious problem, substances, a problem that you need help with. I think to the extent, and I am gonna give you an opportunity to participate in the drug court program. At this point, what I have for Mr. Hamlin is that you would be accepted into it, that you're doing fairly well. We've got some positive tests here that are gonna have to be dealt with. It sounds like you've already received a sanction for that. But it's gonna give you an opportunity at least to participate in this program, and it's really designed for people who do have serious problem. It's not designed for casual users. And I think you fit into that category of somebody who really needs the help. It's my experience with treatment courts in general that we can put a lot of resources towards this and give you the opportunity, but unless you really want to make this change for yourself, all of that doesn't matter. It's got to start with you. It's got to come from you. And if you really want to make that change and work on this, then this could be a really good program that can help you with that. If you don't, then you're going to continue to use, you're going to continue to test positive, and you're going to end up back in front of me. Even with the guidelines as they are, they call for up to 23 months in prison. And if we make these attempts to help you with this problem and you don't accept those, the only other option that I have then is to go the prison route, because we've tried this and it hasn't worked, and now it's time for something different. So you really are, at a crossroads where you can put everything into this program, really work on it, and have a better life and move past this, or you can go to prison. And I want to give you that opportunity. I think it's in our community's best interest to give you that opportunity. And if you don't, then you know what the consequences are. So from my standpoint, there's really no downside to giving you that chance at that. So the court is going to place you on probation as to both files, all charges, for a period of 2 years. The court is going to adopt as the conditions of that probation all the terms and conditions listed in the reports, the most important of which is that you participate in and successfully complete the drug court program. As to file number 6098, which is possession of methamphetamine, count 1. Court is going to order that you serve 10 months in the Otsego County Jail. You have credit for 3 days served. Court's going to hold that time in abeyance to be served at the discretion of the drug court program or the court. A crime victims assessment of $130, court costs of $325, attorney fees of $350, $68 state costs, drug court fee of $600. As to file number 6458, again, probation for 24 months pursuant to all the terms and conditions listed there. And that's as to the weapons charge and the controlled substance possession analog charge. As to both of those files, or both of those charges, 10 months in the Otsego County Jail to be held in abeyance, with credit for 2 days served, used at its discretion of the drug court program or the court. On that file, $130 in crime victims assessment and $136 state costs. You do have the ability to appeal these sentences. And Mr. Gila, have you provided those appellate rights, Ms. Clark?
Yes, Judge, and for the record, she signed the receipt of the appellate right.
Thank you. Mr. Hamlin, does Ms. Clark indicated she already reported today? Does she need to do anything today or just report as she's next required to?
Just as you stated, Judge, thank you.
All right, Ms. Clark, do you have any questions? All right, good luck to you going forward.
Judge,
Yes.
the court's ordering condemnation of the weapon and the drugs.
Yes, I believe I'm required to understand.
You are, Judge, that's
Yeah.
why I asked you.
I missed that, but thank you. Yes. Okay, thank you.
Thank you, Judge.
Supervision.
Ms. Davis? Do I need to impose a supervision fee as well? Or is
That
it?
is the drug court fee.
Oh, so I don't need a separate.
No, you're not.
Okay. Mr. Wilson's fine. Ms. Davis, I have a question on Michael Wilson. That was set for a show cause hearing today.
Yes,
That's still on?
yes.
Yes.
He should be calling in, according to Agent Leo, he is being supervised through IPODs in Ohio. So he should be calling in today, trying to get into veterans. I'll just tell you before he gets on.
Okay.
He's trying to get into the veterans sobriety court in Ohio. Agent Leo was gonna ask for a PR bond for him and then adjourn this out 60 to 90 days. Pending his new charges in Ohio.
Okay. So we're gonna arraign him on
Correct.
the two, or it's like two technical and one non-technical.
Correct.
Okay. And he is joining.
did you want to address Bonamy before Mr. Kilo leaves, or?
Mr. Gila, have you been appointed to this case?
Well, I haven't been appointed yet. He was gonna retain my office and then he went over to Harbor Hall. Haven't been able to make contact with him. Been in contact with his mother. I assume that if you set it out, he's gonna get an attorney one way or the other, either me or a court plan. So if you wanna set it out, or how long? I don't know.
Let me just go on the record in that one. This is People versus Casey Bonamy, case number 216097. Mr. Gila is present here. Mr. Gila has not been yet appointed, but he's had some contacts. Can you just restate that for the record? I'm sorry.
Yes, Judge, I've had contact with his mother. I found out he's in Harbor Hall. I called Harbor Hall and requested contact with him. They've got some rule over there that he can't have outside contact for a period of time. So I'm gonna keep working on it as soon as I get contact with him. Or maybe even before that, I'll file an appearance to represent him one way or the other.
All right.
He is at Harbor Hall. I was gonna ask for a 30-day adjournment. I do not know how long he will be in Harbor Hall. That leaves that 30 days. I can update the court again on what the status is at Harbor Hall. He is there right now. And you did in your, when we did set bond, you said that you would allow him to go. That is where he is.
Okay, all right, and I think that's a good thing.
Yeah.
So thanks for following up on that, and Mr. Gila as well. We'll reset this for a hearing in 30 days. Mr. Wilson, if you're there, I need you to unmute and turn your camera on, please. Wilson, are you able to hear me okay?
Yes, sir. Can you hear me okay?
All right. I can, thank you. We're on the record in People versus Michael Wilson. This is case number 216196. The record should reflect Mr. Wilson's present today by video. We have Ms. Davis here on behalf of probation. This is set for an arraignment today on some alleged probation violations. So Mr. Wilson, I need to go through a couple things with you with regard to your rights. Are you aware of what the alleged probation violations are?
Yes, sir.
Okay. And you understand that if you are found guilty of any or all of the alleged violations, that the maximum penalty you could face would be that on your underlying charge, which is operating while intoxicated as a third offense, which is up to 5 years. Do you understand that?
Yes, sir.
You do have the right to have an attorney present in any subsequent proceedings. If you could not afford an attorney, one would be appointed for you at public expense. Did you want to hire your own attorney, or did you want to see if you qualify for a court-appointed lawyer?
I would like some time to look into both. I'd have to, do that. Yeah, I mean, I'll probably need a court-appointed attorney, but I would like to try to, talk around and stuff.
All right, so I'll hold off on that part of it for now. Do you want me to enter a not guilty plea on your behalf then today with regard to the alleged violations?
I'm not 100% sure exactly what that means.
Would you like me to state on record again?
Sure.
So that he hears.
So, Mr. Wilson, Ms. Davis is here from probation. She's going to tell me right now what their position is on this going forward, okay?
Okay.
Agent DeLeo advised that you are facing these charges in the state of Ohio. You're trying to get into veterans sobriety court presently. He was going to ask for a PR bond to see how things play out there in Ohio. And then he was asking for a 60 to 90 day adjournment to allow all of this to happen, and then for you to update the court if you get into the veterans court there.
Okay. Yeah, that's kind of, yeah, that's where I'm at right now is this program and all that, just trying to get, get right.
All right, so then what I'm gonna do, Mr. Wilson, is I'm gonna enter not guilty plea on your behalf today. That's gonna give you a chance to investigate the treatment court as well as talk to an attorney, okay?
Okay.
And then the court will set this as a $500 personal recognizance bond. So Mr. Wilson, you don't have to post any money, but you need to make sure that you continue to follow through with any reporting requirements from your probation agent, as well as all the terms and conditions of your probation while we decide how to proceed, okay?
Okay.
Ms. Davis, anything further on this?
No, Your Honor.
Mr. Wilson, do you have any questions?
No, sir.
Okay, again, just make sure that you stay in touch with your probation agent and you're free to disconnect at this time.
Thank you, sir.
Right.
Thank you.
All right, Mr. Rolla, the court received, I guess, treated as an ex parte request, but I think it's only because you've been in court and haven't had a chance to respond. But Ms. Ashton's attorney, Mr. Daly, 1045. He is in trial in Macomb County. It's spilled into another day that we didn't anticipate and requested that the court adjourn. It would be my intent to grant that request unless you have an objection to that.
Well, Judge, if he's in court, I don't have an objection, but I would ask to be allowed to make a statement for the record.
Sure.
In that request. As you probably recall, back on October 4th, our office, I received on my personal cell here in court, actually received a phone call from their office from Farah at 248-302-6885. An assistant in the defense counsel Daly's office indicating they had been on Zoom for the last 45 minutes, but no one let into the meeting. I think they actually dialed the wrong Zoom ID number because then we gave them the correct one. So again, he's in court, Judge. I'm not going to object to that situation, but it would be appropriate that they be a little more careful, understanding that it's court orders, it's not merely invitations.
Right, I think that's a fair point. So then I did not recall that previous instance. So the court will reset this, but the court will notify that Mr. Daly that somebody or him or someone from his office needs to be present for that hearing. And no further adjournments will be granted. Okay, that takes us through 11:15. So we'll be in recess until 11:15.
Michael Baird, Your Honor.
People versus Barrett, case number 23660.
Just want to come right up to the podium.
Yeah, yeah.
If I could have counsel took your appearances.
Thank you, Your Honor. Tyler Velo, P75702 on behalf of the defendant, Michael Baird.
I didn't catch your last name.
Velo, VII. Hello.
Okay, we're set for a status conference here in this file today. Mr. Buell, can you tell me where things are at from your standpoint?
Yes, Your Honor. We've had some discussions with the prosecutor's office. He has made an offer. I've relayed that to my client. We are still discussing possible resolutions to this case.
Okay, how much time do you need for Mr. Barrett to have made a decision about it?
I think another month or so would be good.
Mr. Rolla, any objection to that?
No, Judge, there is a plea offer. It's plea to count one with the, of course, the $200 blood test fee as required by statute. Dismiss counts 2 and 3 as well as the habitual third. It makes a significant difference in regards to the defendant's scoring.
Okay. All right. Mr. Barrett, do you have any objection to the court adjourning for about 30 days?
No.
Okay. So we'll set this for a status conference plea hearing in about 30 days. During that period of time, Mr. Barrett, I'm going to need you to talk to Mr. Velo. And once we're back, I'll need you to have made a decision about whether you want to accept that plea offer or whether you'd like to go to trial.
Okay.
That's going to be a plea cutoff date. So once you decide on that date, that'll be final going forward. Okay. So it's important that you discuss it with Mr. Velo and that you're ready to proceed with a decision at that time.
Okay.
All right. Mr. Velo, anything further I can address for your side?
Nothing further. Thank you, Your Honor. Will the court be mailing notices?
Yes.
Perfect.
Send it out just as we did for today's hearing. Mr. Rolla, anything else that you need to address?
No, thank you.
Thank you. Can I have this Lindstad spot?
Certainly.
Nice to see that last out this morning. All right, Ms. Carver, are you able to hear me okay?
I am, yes.
All right, we're on the record in People versus Lindstad. This is case number 216148. The record should reflect counsel on behalf of Ms. Lindstad. Ms. Carver is present by Zoom. Mr. Rolla is present here on behalf of the people in the courtroom. Ms. Lindstad was written for 11:15. It's now a little bit past 11:20. I don't see her in the Zoom waiting room. Ms. Nelson, or I'm sorry, Ms. Carver, have you had a chance to speak with her at all recently?
Not recently. I wasn't able to schedule another visit with her. We're likely going to withdraw the motion. We've had a lot of discussions and I know her desire is not to withdraw her plea. And if insurance didn't cover it, then we accept that from the prosecutor.
All right.
And I did hear from the victim's advocate as well. I got a response from the prosecutor, and the victim's advocate reached out to Ms. Smalls, and insurance did not cover it. That was just a misconception, I think, at a previous hearing that I caught my attention, so.
And Judge, it was a PLPD situation, so.
Okay. All right. Ms. Carver, do you want to withdraw the motion today on the record? Do you want
Yes,
to adjourn it?
I'll withdraw the motion on the record, and go forward and speak with Ms. Lindstad outside of court.
Okay, all right. Can you just submit something in writing to the court? I know we've got it on the record here today, but if you could submit the written withdrawal as well. That way we have that for the court file, and then we won't conduct any further proceedings.
Okay, is the prosecutor that I should send that to?
Judge, if she wants to just send it by email to our office, she can do that, and then I can review it and give her permission to sign it and submit it right to the court.
Okay, I will do that. I have the email that I got the response from.
Very good, that'll work. Thank you.
All right,
right.
thank you.
Thank you. You're free to disconnect. Next hearing is by Zoom at 11:45, so we'll be in recess until that time.
We're on the record in People versus Nelson, case number 226252. Mr. Roll is here present on behalf of the people. This is Mr. Fragel's motion as defense counsel to withdraw. Set for 11:45. It's now a couple minutes after. I don't see Mr. Fragel in the Zoom waiting room. Has he reached out to your office at all, Mr. Roll?
That's what I'm checking out right now, Judge. I don't see anything recent, nothing since the motion to withdraw that was filed on September 27th and scheduled for today's date.
Okay. All right. Well, I'm just gonna, of course, not gonna make any rulings at this time. I guess if Mr. Fragel wants to renotice it, he can do that. I would note for the record that Mr. Nelson is not present here in the courtroom today or in the Zoom waiting room. And it looks like he's been at large since March 2022.
Actually, Judge, our file indicates February 9th, 2022, the defendant advised he was, quote, going back home to New Mexico. And at that time, warned Judge Cooper that this would occur. And he told his own attorney at that time he wasn't going to appear for any further court proceedings.
Okay. All right. Well, we have a bench warrant. Yeah, we have a bench warrant active. If he ever does come back to Michigan, we'll have to proceed from there. Otherwise, Mr. Fragel will remain counsel of record until he can get his motion heard. That concludes our docket for the morning. We'll be in recess until 1:30.
Judge, you saw the Hampshire matter on the docket?
For the morning?
Yes, I showed.
I thought it was for this morning.
It's not on my docket and it's not on the schedule for it, so.
It's on mine, and it's another motion to withdraw from Fragel.
I'm not gonna call it because I don't have it on. So something may have happened in the interim.
In between.
Yeah.
Very good, Judge. Just figured I'd mention it before you went.
No, thank you.
Thank you.
Yeah, it wasn't on my